Welcome back to Cybersecurity Law and Policy. Now we're going to take on a subject that we've been following for some time, and that is net neutrality. So what has happened in net neutrality and what has been the role of the executive branch? Well, we know that the FCC is the regulatory agency for the internet and net neutrality. So it's the FCC who's promulgating regulations. This started in the President Obama administration, where net neutrality was an effort to make sure that there were not discriminatory practices and who had access to the internet and who did not, mainly by preventing the flow of speed to the higher paying subscribers versus those who might be individual subscribers or those with lower cost plans. So obviously this is to make sure that providers make more money by giving higher speeds that they could charge more for to wealthier clients. So in an effort to try to make sure that this did not create a class system on the internet, net neutrality was the solution. So let's see what's happened with it. We'll take a quick look at the timeline, and this is a long one. So you can see net neutrality actually started out as a concept back in 2003, and it didn't really make it to regulatory stage until about 2010 when the FCC created the Open Internet Rules. And those established high-level rules requiring transparency and prohibiting blocking and unreasonable discrimination to protect internet openness. And in January 2014, the ruling in Verizon vacated significant parts of the open internet order. So we have some controversy about whether this is something that that actually can be created by the executive branch in a rulemaking. So let's start with 2014 now. Jump to May 2014 when the FCC releases new promulgated rules. It allows the rules to have a fast lane and a slow lane online. June 2014, FCC investigated large companies such as Netflix for their interconnection policies and how they were treating subscribers. In May and July 2014, the FCC opens up the public knowledge for public comments, and that is any rulemaking requires a time for notice and comment. And so it was during this time they received 1.1 million comments, and at one point crashing the site, ironically. And they also concluded that less than 1% of the comments were clearly opposed to net neutrality. So in September 2014, the FCC received 3.7 million comments. In February 2015, the FCC passes the Title I net neutrality rules. So this is now 2015. And in June 2015, net neutrality rules go into effect. So finally, net neutrality becomes the law in 2015. June of 2016, new rules are upheld by the U.S. Circuit Court of Appeals for the District of Columbia. And then January 2017, President Trump names a new director for the FCC who is strongly opposed to net neutrality. So in April 2017, the FCC, new chair, announces a plan to reverse these regulations. And remember, it is the executive branch, so they can change regulations. They have to go through the notice and comment period to withdraw regulations, just like they do to promulgate regulations. So May 2017, a U.S. appeals court declined to reconsider a rehearing of the net neutrality case, which would make sense. But those who didn't want the rules were withdrawn were trying to use the court system to prevent that. And then May 2017, the FCC voted 2-1 to start rolling back net neutrality regulations, and this vote really started the beginning of this whole process of modifying the existing rules. And but so far it didn't actually change any of the rules. By December 2017, the FCC voted 3-2 along party lines in favor of reversing the regulations. And then February 2018, the Restoring Internet Freedom ruling was published in the Federal Register. It gave Congress the opportunity to nullify it by voting against this pronouncement in the Federal Register. The Congressional Review Act is an interesting new mechanism, relatively new, that if the executive branch promulgates a regulation that Congress believes is contrary to the law or something that was passed by Congress, then they can, by vote, withdraw those regulations. Now, a lot of people think that might be unconstitutional and giving the legislative branch too much power over the executive on how to run and implement the law. But the point is really to make sure that it is the law and not violating the law that Congress passed. So far, the Congressional Review Act has survived. So, however, May 2018, the U.S. Senate passes the CRA resolution on a 52-47 vote in an attempt to stop the repeal from going forward. But June 2018, the U.S. House of Representatives failed to act under the CRA or would have prevented the repeal of the FCC rules. So when the House failed to act, they failed to repeal they failed to override the repeal of the rules proposed by the executive branch. So the withdrawal took effect. So by August 2018, the states started to take action on their own and create their own net neutrality rules. 22 states actually went to litigate this to see if it was legal for the states to do this. The states did act on net neutrality. September 30, 2018, we see California do it, and then in June 2019, Maine also took action on net neutrality. Now, what are some problems with net neutrality, and why would this even be a concern? Here's one of the problems. A Santa Clara Fire Marshal, Anthony Bowden, explained about how, in the Verizon case, how the slow device speeds during the fire crisis in California actually hindered firefighters' responses. Bowden writes in the brief that was filed with Verizon in 2018 in the Verizon case that the fire department had purchased an unlimited data plan from Verizon for a support unit's connection. But the company started throttling speeds to 1/200th or less after the unit hit the 25 gigabytes of use. Bowden writes that resulting throttling from Verizon, quote, had a significant impact on our ability to provide emergency services as responders were unable to properly track and route firefighting resources. The company continued to slow data speeds even after being informed it was actively impeding responders' ability to fight the blazes. Bowden writes, ultimately, the fire department had to sign up for a new, more expensive plan before speeds were restored. So in February 2020, the FCC reviewed the rules again. So in February 2020, the District of Columbia Court said that the FCC cannot prevent states from passing their own net neutrality rules. And part of the reason for this decision was the effect on public services, like the Santa Clara firefighters that you heard from in the previous Verizon case. So where are we with net neutrality? Well, it's likely it's going to be decided on a state-by-state basis, the way it looks at the present.